Welcome to S&C Critical Insights. I'm Jeannette Bander, a partner in S&C's Executive Compensation Group, and I'm joined today by Annie Ostrager, the co-head of our Employment Law Group and a member of our Workplace Investigations Group. When we last discussed non-compete agreements, we previewed that we'd provide an update after the FTC voted on its long-anticipated non-compete rule and in light of anticipated litigation. As expected, on April 23rd, the FTC adopted, by a vote of 3-2 along partisan lines, a final rule containing a sweeping ban on non-competes. The final rule would have operated to broadly ban non-compete agreements that continue after the conclusion of employment and would have had retroactive effect except with respect to senior executives as defined under that rule.
Yes, Jeanette, good to be back with you to talk about this topic, which has attracted a lot of attention over the last few months. Where things stand now is in a posture that was likely welcomed by many employers, which is that the rule will not take effect because of a decision that came down at the end of last month in Chamber of Commerce v. FTC and Ryan v. FTC. In those cases, the Northern District of Texas issued a nationwide permanent injunction setting aside the FTC's rule banning non-competes. Prior to its ruling on the injunction, the court afforded temporary relief to the rule's application, but that relief was limited just to the named plaintiffs. The court's subsequent decision granting the permanent injunction, though, was not confined to the named plaintiffs, and instead the court held broadly that the FTC's rule shall not be enforced or otherwise take effect anywhere. The court first found that the FTC exceeded its authority under Sections 5 and 6G of the FTC Act, neither of which authorizes the Commission to issue substantive rules on unfair methods of competition. The court also held that the rule was arbitrary and capricious in violation of the Administrative Procedure Act because the rule was based on inconsistent and flawed empirical evidence. The court also concluded that the FTC failed to consider the benefits of non-competes. Earlier this summer in July, in ATS Tree Services v. FTC, the Eastern District of Pennsylvania went the other way, declining the plaintiff's motion to stay the rule, finding, among other things, that the plaintiffs in that case had failed to show a likelihood of success on the merits. Although this decision did not formally uphold the rule, it suggests the Eastern District believed the rule could be within the FTC's authority, staking out a different position from the Texas court. The FTC has said it is seriously considering appealing the Texas decisions in Ryan and the Chamber, and any further litigation that does take place will unfold against the backdrop of the Supreme Court's decision from this past term in Loper-Bright, in which it struck down the long-standing principle of Chevron deference when dealing with agency decision-making. The FTC has until October 19th to appeal the court's ruling.
In the meantime, companies and employers should be aware that the injunction preventing enforcement of the FTC rule does not have any effect on other non-compete legislation. Companies should therefore continue to ensure that any non-competes are within the bounds of applicable state laws, many of which impose significant limitations on non-competes. At the state level, there are signs that the tide is turning against the use of non-competes. Last year, Minnesota joined California, North Dakota, and Oklahoma in enacting a blanket ban on non-competes, and 33 other states have imposed restrictions on their use. Here in New York, non-competes continue to be a focus. At the end of 2023, Governor Hochul vetoed the New York State Legislature's proposed ban on non-competes. Governor Hochul explained, however, that she would support a non-compete ban in New York as long as it struck the right balance between protecting workers and allowing New York businesses to retain talent. In response to the governor's veto at the state level, in February of this year, the New York City Council introduced Bill 140, which would ban virtually all non-compete agreements in New York City. The bill would prohibit non-competes with paid or unpaid employees, as well as independent contractors. At the same time that they introduced Bill 140, the New York City Council also introduced Bill 146 and Bill 375, which impose lesser restrictions on the use of non-competes in case Bill 140 does not pass. Bill 146 would ban non-competes only with low-wage employees with some exceptions, and Bill 375 would ban non-competes only with independent contractors, again, with some exceptions. Thank you for listening to S&C Critical Insights. For more information about our practices, please visit us on the web at www.solcrom.com.